Have you ever opened your mailbox, seen another bill from a collector, and felt that familiar knot of worry tighten in your stomach? You're not alone. For so many of us in our later years, what should be a time of peace and relaxation is instead shadowed by the weight of old financial obligations. We were raised to pay our debts, to be responsible, to keep our word. And that's an honorable way to live. But what if I told you that the rules of the game have changed? What if the very laws designed to protect consumers are actually on your side, offering you a path to financial relief that you might not even know exists? You see, many of the debts that haunt us, those old medical bills, credit card statements from a decade ago, even certain loans, can lose their legal power over time. Yet collectors keep calling. They use pressure, they use fear, hoping that our sense of duty will outweigh our knowledge of the law. Today, we're going to change that. We're going to sit down together and talk about 6 specific types of debts that lawyers consistently advise seniors they can legally walk away from. This isn't about shirking responsibility. It's about understanding your rights so you can protect your hard-earned retirement income and finally breathe easy. Let's start with a big one, probably the most common source of anxiety for many of us: old medical bills. Over a lifetime, medical expenses pile up. A surgery here, an emergency room visit there, maybe a specialist appointment from years back. The statements keep coming, or a new collection notice arrives, and that feeling of dread returns. But here's something crucial that often gets lost in the fear. Old medical debt has an expiration date. It's called a Statute of Limitations. Every state sets a limit on how long a hospital, a clinic, or a collection agency has to legally sue you to force payment. In some places, that might be as short as 3 years. In others, it could be 5 or 6. Once that time period passes, the debt becomes what's known as time-barred. Now, that doesn't mean the calls will magically stop. They might continue. But it does mean the legal threat behind those calls is gone. They cannot take you to court over it. And here's the most important part for us seniors. By federal law, your Social Security benefits are protected from most creditors. They cannot garnish your Social Security check. No matter how threatening a letter or phone call might sound, that income is legally shielded. It is for your survival. I want you to think about that for a moment. How many months or even years have you been setting aside money from your fixed income to pay down a medical bill from the distant past? I remember a woman named Margaret who wrote to me. She's 74, a widow, and for years she diligently paid $150 every single month toward a hospital bill from nearly a decade prior. She was terrified that if she didn't, they would come after her small savings or her Social Security. It wasn't until she spoke with a free legal aid clinic for seniors that she learned the statute of limitations in her state had expired years earlier. All that money she had been paying, money she desperately needed for her prescriptions and groceries, she didn't legally have to pay a cent of it. The relief she felt was immeasurable. So if you're getting calls about an old medical bill, your first question should always be, how old is this debt? If it's beyond your state's time limit, you can confidently let that burden go. Now, let's talk about another common shadow from the past: old credit card debt. That credit card you cut up and stopped using 15, maybe 20 years ago, you might still be getting notices about it. Just like medical debt, credit card debt is also subject to a statute of limitations. Once that time period elapses, the debt becomes time-barred. The company or the collector who bought the debt for pennies on the dollar loses their right to sue you to collect. But there's a trap here, a very sneaky one that catches many well-intentioned people. In most states, if you make even a single small payment on that old debt, or if you even verbally acknowledge that the debt is yours to a collector on the phone, you can accidentally restart the entire clock on the statute of limitations. Suddenly, that old, expired debt is new again in the eyes of the law, and they regain the power to sue you. This is why it's so vital not to act out of panic when you get one of those calls. Take a deep breath, don't promise anything, don't agree to anything. Just take down their information and tell them you will look into it. I think of Robert, an 78-year-old retired mechanic. He was being hounded by a collection agency for a credit card he had forgotten about, with threats of lawsuits and wage garnishment. Fearful, he almost sent them a $50 good faith payment. Thankfully, he mentioned it to his daughter first, who helped him find the information. They discovered the debt was from 2003, far beyond the legal time limit in his state. He never sent that payment. He sent the collector a letter stating the debt was time-barred, and the calls eventually stopped. His Social Security remained safe and sound. That's the power of a little knowledge. It gives you back control. It replaces fear with confidence. If you're finding this helpful, if it's easing your mind even a little bit, please let me know by commenting number 2 down below. It really helps me know I'm on the right track and that this information is reaching the people who need to hear it most. And if you haven't yet, please consider subscribing to the channel and tapping that little bell icon. It's completely free, and it helps us continue to create content that protects and informs wonderful people like you. Now let's keep going, because there are more freedoms you need to know about.
Now, let's talk about a debt that causes an immense amount of worry, not just for ourselves, but for our families: student loans. So many of us carry this idea that student loans are forever, that they're a weight we can never put down, and that they might even pass on to our children and grandchildren. While it's true that federal student loans have very strict and often unforgiving rules, the story can be very different for certain private student loans. This is a nuance that many collectors won't ever bring up. You see, private student loans, much like credit cards or medical bills, are also subject to that same principle we've been talking about, the Statute of Limitations. If you or a child you co-signed for took out a private loan for school many years ago and it went into default, there's a very good chance that the legal time limit for the lender to sue for repayment has expired. They can still call, they can still try to pressure you, but if that statutory clock has run out, their power to force you to pay through the courts is gone. This leads to the second and perhaps even heavier worry: what happens when we're gone? We work so hard to leave behind good memories and maybe a little something for our families, not a burden. Here is a critical piece of information that can lift a huge weight off your shoulders. Federal student loans are typically discharged upon the death of the borrower. And for private student loans, in the vast majority of cases, that debt does not automatically transfer to your spouse, your children, or your estate unless they co-signed the original loan. Let me say that again. Unless your child's name is also on that loan paperwork as a co-signer, they are not legally responsible for your student loan debt after you pass away. The responsibility ends with you. I want to share a story about a viewer named Linda. Linda is 82. Decades ago, she took out a private loan to get a teaching certificate. Life took a different turn, she never used it, and the loan eventually slipped into default. For years, she sent what little money she could, terrified that if she didn't, her beloved grandchildren would be stuck with her debt. It was a source of constant guilt and anxiety for her. Finally, her son convinced her to speak with a lawyer at a senior legal services nonprofit. The lawyer looked at her paperwork and gave her 2 life-changing pieces of news. First, the statute of limitations on her loan had expired over a decade ago. She hadn't needed to pay a single cent all those years. And second, even if that weren't the case, her grandchildren could never have been held responsible for it. She wasn't leaving them a burden. When she told me this, she said she cried tears of relief for the first time in 30 years. She could finally use her limited income for her present needs, not for a ghost from her past. Understanding this can change everything. It's not about getting out of a legitimate obligation. It's about recognizing when the obligation itself has reached its legal end. The fear of burdening our family is often far heavier than the debt itself. By knowing the truth, you can let that fear go and focus on the people you love, free from that unnecessary worry. This brings us to a different kind of debt, one that doesn't come from a faceless corporation, but from someone we knew. I'm talking about personal loans from friends, family, or neighbors. These are often the hardest debts to carry because they're tied to memory, to relationship, and to our own sense of honor. Many of us still lie awake at night thinking about money we borrowed from a cousin 40 years ago to fix a car, or from a dear friend who has since passed away to help make ends meet during a difficult patch. Legally, if these loans were made on a handshake without any formal written agreement, or if they're so old that they've far surpassed the statute of limitations for contract disputes in your state, they are almost certainly unenforceable. No court would force you to pay. There is no collector involved here. The only collector is your own conscience. But it's important to ask yourself, are you sacrificing your present peace for a debt that the law itself has declared over? Life happens. We've all faced hardships, illnesses, and surprises that rearranged our best-laid plans. If the person you borrowed from never took formal action to collect within the legal time frame, the matter is considered closed. Holding on to that guilt only punishes you now for a situation that is long in the past. I remember a letter from a wonderful woman named Helen. She was 81. Decades ago, she took out a $50 loan from a fellow church member back in 1975. The friend had passed away 20 years prior, yet Helen still felt a deep shame, as if she had failed morally. One day, she mentioned this in passing to her daughter. Her daughter gently explained that not only was the debt legally extinct, but that carrying it for 45 years was honor enough. She had more than paid it back in worry. That simple conversation offered Helen a forgiveness she couldn't give herself. She was finally able to close that chapter. As seniors, we have to learn to extend to ourselves the same grace and understanding we so freely offer to others. You are not defined by a financial situation from decades ago. Your value is in the life you've lived, the people you've loved, and the wisdom you've gained. Let the law and the passage of time relieve you of these personal handshake debts. You have earned your peace. If this is making sense to you, if it's helping you see your financial situation in a new light, please let me know by commenting number 4 down below. Your comments are so important. They help me know what matters to you, and they help others in our community feel less alone. And if you can, please hit that subscribe button and turn on notifications. It's the best way to make sure you don't miss the final part of this important conversation, where we'll cover the last 2 debts you can walk away from. Thank you for watching, and thank you for trusting me with your time.
Now let's turn our attention back to a topic we touched on earlier, because it's so important it deserves its own spotlight. Expired medical debts. I know for so many of us, a medical bill can feel like the most urgent, the most frightening piece of paper to arrive in our mailbox. It's tied to our health, to moments of vulnerability, and that gives it a unique power to scare us. We might see a bill from a hospital stay years ago, or for a procedure we've long since forgotten about, and that old anxiety comes rushing back. We worry they'll refuse us care in the future, or that they'll finally come to take our home. But please, hear me on this. Just like any other consumer debt, medical bills have a statute of limitations. Once that time period, which varies by state but is often between 3 and 6 years, passes, the debt is legally unenforceable. What happens so often is that the original hospital or clinic sells this old, unpaid debt for a tiny fraction of its value to a third-party collection agency. These agencies then use high-pressure tactics, hoping the urgent tone of their letters and calls will make you pay without question. They bank on the fact that you respect your obligations and that you fear the consequences. But the reality is starkly different. An expired medical debt is just that, expired. They cannot get a court judgment against you. They cannot garnish your federally protected Social Security income. They cannot put a lien on your primary home in most cases. And perhaps most importantly, a hospital cannot deny you emergency medical care in the present based on an unpaid bill from your past. Your health and safety are paramount, and the law protects that. Let me tell you about a man named Arthur. Arthur is 80 years old. He received a collection notice for a bill related to a heart procedure he had back in 2005. The amount was staggering, and the letter threatened legal action if he didn't set up a payment plan immediately. For weeks, he didn't sleep, agonizing over how he would ever come up with the money. Finally, he confided in his grandson, who helped him do a little research. They discovered that in his state, the statute of limitations for medical debt was 5 years. This debt was nearly 2 decades old. It was a ghost. It had no power over him. The relief he felt was physical. The constant, low-grade fear that had taken up residence in his chest just vanished. He wrote a simple letter stating the debt was time-barred and never heard from them again. That knowledge gave him back his peace, and that is priceless. Your health and your peace of mind are what matter most now. You should not be sacrificing your present well-being for a medical debt that the law itself has declared null and void. You have a right to that knowledge, and you have a right to that peace. Finally, let's talk about a worry I hear from so many seniors, a concern that touches on the very thing we want most for our families: utility bills after we're gone. Many of us lie awake worrying, if I pass away with an unpaid electric bill or an overdue water bill, will my children be stuck with it? Will I be leaving them a mess? This fear is so common and so deeply felt because it's about protecting our loved ones from any extra burden during a time of grief. I want to be very clear and direct here to ease your mind. Unless your child or spouse is a co-signer on your utility account, meaning their name is officially on the paperwork as a responsible party, they are not legally obligated to pay your unpaid utility bills after you pass away. These are debts that belong to you, the account holder. When the time comes, your family simply needs to notify the utility company of your passing, provide a copy of the death certificate, and the account will be closed. Any outstanding balance will be written off by the company. It does not transfer to your heirs. Now, collectors might try to suggest otherwise. They might call a grieving family member and imply they have a moral, if not a legal, responsibility to settle the account. This is a pressure tactic, pure and simple. Your family is not responsible. The only thing they might need to do is open a new account in their own name if they are taking over the residence, and they will only be responsible for charges from that point forward. Think of Robert, who we mentioned earlier. His final years were clouded by the worry that his son would be hassled by the gas company for a few $100s. When he learned from an attorney that this was simply not the case, that the debt would die with him, it was as if a physical weight was lifted. He could focus on what truly mattered, sharing stories, looking at old photos, and simply enjoying the time he had left with his family, free from that particular worry. You have worked your entire life. You have raised families, built careers, and contributed to your communities. These later years should be defined by dignity, by peace, and by the joy of time spent with loved ones. They should not be dominated by fear over debts that have expired, that were never enforceable to begin with, or that will not pass on to your family. The common thread through all of this is knowledge. Knowledge replaces fear. Understanding your rights gives you back a sense of control that collectors rely on you not having. From old medical bills and time-barred credit cards to certain student loans, personal handshake agreements, expired medical debts, and utility bills, the law provides protections that can set you free. So the next time that envelope arrives or the phone rings, I want you to take a deep breath. Remember what you've learned here today. You have the power to ask, how old is this debt? You have the right to verify. You have the right to protect your peace and your financial security. Your well-being is the most important thing. You deserve to use your retirement income for your life today, for your health, for your happiness, for your family, not for ghosts from yesterday. Thank you so much for joining me for this important conversation. I would really love to hear from you. Please leave a comment below and share one thing you learned today that surprised you or gave you relief. Your stories and your thoughts are so valuable, and they help others in our community feel supported and understood. If this video brought you peace of mind, please pay it forward by giving it a thumbs up and sharing it with a friend who might need to hear this message. And if you haven't already, please subscribe to the channel and tap that bell icon. It's completely free, and it helps us continue to create content that empowers and informs you. Thank you for watching. Remember, you are not alone, and you have more power than you think. Take care and stay blessed.